sometimes there's convergent without bad faith, convergent creation of things, right? Like go back to calculus. Leibniz and Newton create things essentially contemporaneously and independently when it comes to calculus. But the roughly contemporaneous would get resolved in the blockchain world because you'd say, well, yeah, Leibniz did it on October 1st, but too bad because in September when Newton started writing Principia, but it would be settled on a blockchain where everybody could see it. There's a lot of value to that, and that would reduce some of the inefficiencies in the copyright world because you wouldn't have to fight it out and lawyers wouldn't have to get involved other than to say, here are the timestamps.
Welcome to Grokchain Conversations. This podcast is presented by a multidisciplinary group of legal, financial, and technology professionals to meet and discuss today's most pressing questions around the use and governance of the blockchain. Through roundtable dialogue, we will provide listeners with a full spectrum of views on where this technology is today and where it might be leading. The information provided on the Grokchain Conversations is for educational purposes only. The information provided does not constitute legal, investment, financial, tax, accounting, or any other professionally licensed advice. The views expressed here are those of the individuals, not those of their respective employers or Grokchain. Today's topic: what are compositional contracts?
All right. Hello, everybody. Welcome again to another Grokchain Conversations episode. My name is Chris Ott. I'm a U.S.-based attorney. I have a background in U.S. regulation of financial markets and also law enforcement reactions to the same. In private practice, I represent a number of individuals and companies in active business litigation related to blockchain technologies and also regulatory and law enforcement investigations. I work every day in kind of the worst case scenario of blockchain technologies. I'm joined here today by Martin Warner and Fab Genovese. And Martin, could you introduce yourself to us?
My name's Martin Warner. I'm currently building TGrade, which is a blockchain that is based in the Cosmos ecosystem, the Cosmos technology stack. And we're looking to bridge the regulated financial world to the world of blockchain.
I am a mathematician, and maybe you can say blockchain architect. The thing I'm really interested in is called compositionality, that is the study of creating complex systems out of simple parts in a way so that some key properties you care about are preserved, so that complexity actually is tamed and doesn't spin out of hand. What I'm working on as of late is in particular some stuff called open games, that is a compositional version of game theory that allows to compositionally, like to design games, a system of modules that then can be wired together and can be tested for financial incentives and stuff like that.
Cool. Now, Fab, we're here today to talk about compositional contracts. And I'm told that this is a theory that's literally hours old.
Yes. Yeah.
You explain to us what we mean by compositional contracts. You're just talking about compositional sciences.
Yeah, so basically compositional contracts is a term that, it's basically been made up a few days ago, I would say. The idea was born during a conversation with Anja Blaj, that is a legal professional from Slovenia, that at the moment is involved in designing a sort of protocol standard for NFT licensing. That I think their goal is ultimately to propose it as an EIP in the Ethereum ecosystem. And she was basically telling me that they have this problem that on one hand there is like the legalese, let's say, that is what actually matters in court. But the way the blockchain world works is that you often reuse material that is on the blockchain, especially in the case of NFTs, for instance. You can do what are called remixes. That is, you take some existing NFTs and you put them in your NFT and you create a new NFT about it. And the point is, all these NFTs will have some licensing written in legalese somewhere, but you want also a kind of standard that, you know, allows you to say, to understand very quickly if you can use that NFT in your work or you can't, what are the royalties, what are the conditions, without having to go through all the license. So this is what she was designing together with other people. And when she told me about it, basically I had this kind of idea of basically creating a way to write legal contracts that works in a similar way to how a packet manager works in a Unix ecosystem. So let me try to unpack this kind of definition. When you are on Linux, one of the most famous operating systems out there, you can download packages that basically are new components. So for instance, I can download Zoom, that is the application we usually use to do streaming. And I can do it from command line. As soon as I say, please download Zoom, the point is that this application may depend on some other components to work, okay? So basically what you have is that the packet manager is this application that keeps track of everything you need to run that application and automatically will download all the needed modules for you. Even more importantly, if you have a module installed on your computer that is incompatible with some of the modules you are downloading, the thing will just produce an error and will say that you cannot install that application unless you remove that module first. So it's a way to keep things tidy and not to have to keep track of everything at the same time. Now, the idea of compositional contracts, and in these sentence contracts is used not as in smart contracts, but as in legal contracts, is basically, the idea is that basically we would like to define contracts not as monolithic objects, but has a quote unquote sequence of nuggets of law, small legal bits that are composed together. So in the most stupidest example I can do, if you think about a contract and you try to divide it in some way, you could divide it in paragraphs, right? Now, there are some paragraphs that somehow stand on their own and make sense on their own. And there are other paragraphs that will need some previous paragraph to make sense. So for instance, you have some initial paragraphs where you define the dramatis persona. You say, customer means this, client means that. And then you reuse those terms within your contract. So you can build the graph by saying, this part of the contract needs this other part of the contract to work. So the idea is we could define these sort of single small bits separately, put them on the blockchain as NFTs or something, as tokens, whatever. And then you say, my contract is just a sequence of this thing. And we can build a packet manager that, for instance, will tell you, hey, if you include this bit and this bit in your contract, there is a serious possibility that they will be incompatible and that your license will be troublesome. In the same way, as soon as I take two NFTs that point to different licenses built in this way, and I include them in my NFT, the packet manager can basically look at how these licenses are composed and say, hey, these two things are not going to be compatible as they are. Again, this is not like legal advice, because in the end, it will be a court of law that will interpret the law and establish if that's the case or not. But the idea is that this thing will give you a very clear indication, will prompt a warning and would say, hey, pay attention, this could get you in trouble. So maybe it's wise to ask for an exemption to whoever produced this NFT if you want to include it. And that is the main idea that we have come up with.
To unpack your example there, I guess the two examples, and correct me if I'm wrong, Fab, I'm just trying to understand because it's a new idea. You use the example of the packet manager, right? And so what you're doing there is you're managing kind of relationships, but they're relationships within the world of computing, right? The way applications relate to each other and how they work together. The step here is you're taking something extrinsic to the computer world. You're taking these legal contracts. You're trying to systematize them and at least be able to highlight how there may be troubles in making them work together. In the example you've got there, if you've got the numbered paragraphs and whatever it is references paragraph 7 and 20, but not 3 that has the definitions that you're talking about, it'll raise a flag and say this doesn't appear to structurally work. Go to the next level. It doesn't propose to solve the legal issue, but it does propose to highlight when there could be a problem because you're systematizing the legal thing. Does that make sense?
Yeah. I want to say also, I'm not a legal scholar myself, not at all. And I don't think that this thing will be of any legal value as it is. Because in the end, again, it's a court of law that decides the interpretation of a given contract. But this is basically is going to be, in my opinion, a possible tool that makes, for instance, an artist's life easier. It's not thinkable that an artist has to consult a lawyer every time they want to include some NFT in their work. So at least they have this thing that, can tell them, yeah, this is going to work, or maybe you should think about it more.
Well, you're right in that the final word on legality won't be settled by this ever. I think that's true because those systems are all going to be extrinsic to computer systems. However, the legal world works on things like intent, willfulness, bad faith, and if these become standardized, they very well could read into whether somebody's operating in good faith when it comes to a copyright issue. By way of example, right? You could say, look, no, I use the standard compositional contracts protocols on this, and I came through clean. How could I possibly be acting in bad faith? And whether there's a legal problem or not, that affects your liability. So there is legal value in it, at least in evaluating it. Now, Martin, I know you've been working on, or at least pondering some similar questions. Can you tell us what you've been thinking about on the NFT copyright front?
A couple of things that strike me there is like a bit like the packet manager. And when you start a legal document, again, I'm not a lawyer, I'm more from the software side of things, but you have a whole set of recitals. What does each term mean? And I can see that being very nicely packaged up into separate NFTs that you pull together. So what do I mean by customer? What do I mean by author, etc.? What got me thinking there was like, legal frameworks operate on countries, national jurisdictions, or across blocks. So I can imagine it can get very complicated very quickly. So like you could have under English law, English and Welsh law, under Scottish law, under French law, whatever it is. Each one of these things will be recital a definition. And so, yeah, it could be. I'm trying to get my head around this. Like, if you say, okay, this is under English and Welsh law, and I'm going to pull in all these particular parts and say, well, actually, this is more Napoleonic code. It's nothing to do with common law. Therefore, it wouldn't be compatible. I don't know if you really go down to that granularity, but that's where I'm I'm not looking for problems necessarily, but I'm just trying to gauge my head around the complexity. So that's the first thing that jumped up there. Or whether it's
from a legal perspective, I agree, because you've got hundreds of countries, all of which have at least some interpretation of these things. However, there is a lot of commonality, specifically when it comes to copyright law. There are copyright treaties that basically every country in the world has signed off on. So if your building blocks for the NFTs are the agreed upon terms for the purposes of interoperability under copyrights, and in the Anglo-American legal world, you refer to as comity, which is kind of respect for other systems and implementation of those systems within. It seems like there's at least some opportunity to systematize these things because there's the commonality. It could never be % for the reasons you're talking about, but maybe it's the starting point.
Yeah, that gets me on to the next one about, all the various copyleft, copyrights, and so on, because they're fairly standard, and common creatives is well understood as a methodology. and it's already used widely for publication of written material, for photographs and so on. So I guess that's where it really comes in. And what could be quite interesting is if you're assembling a number of NFTs together, so you're mixing them to create your own one, you'd almost have to have like precedence, just in the same way as software. If you're licensing everything under Apache 2 and you have one GPL3, then you have to make the whole thing GPL3. You can't put it down to the lowest common denominator and say, well, automatically, because I've used everything else as Apache 2. So I guess that could be quite an interesting way of looking at it, is let's have a look at, what's the highest level of copyright, and then that sets your benchmark.
Yeah, this is exactly one of the examples I had in mind. Is the licenses like AGPL, I tend to call them hereditary, in the sense that as soon as you use them, everything after them has to inherit that license, right? Now, imagine that I have two licenses that are hereditary in this sense, but they are not the same thing. Then it becomes very, very easy to point out something that is way more than a warning. It's just like a certainty. Say, hey, you won't be able to honor these two licenses at the same time. So you cannot include these two pieces of work in your work at the same time. You will go, we will have trouble 100%. So for this kind of like very evident situations, I think this would really be kind of nice tool. And then I also agree with what Chris said. This was born exactly in this idea was born exactly in this context of copyright and licensing, basically. That is somehow seems to be at least way more international than other things. I don't think we would have any hope to apply something like this at this stage to like any sort of contracts, also because contracts tend to be awesomely complicated. While usually, licensing stuff, it's a bit simpler, maybe.
One dimension that could be very interesting is that, say we have like a Creative Commons, and it's been designed really for something published, and then someone gets hold of this and then they inherit that license, as it were. So you're buying a CD or a vinyl that's popular nowadays, it comes with this type of license that you can't reproduce, whatever, which is fine for the physical world. But the digital world, it gets a lot more interest because you can start adding more dimensions onto it. Say, well, you can have this for a trial period of 30 days. It's yours, it's Creative Commons, you can use it, but at the end of that, it expires. You don't have that concept in the physical world. You cannot expire a piece of vinyl. This is where you could get some quite interesting scenarios about, maybe you buy an NFT for a short period of time to try something out. I want to experience this book, this music that comes with it, whatever. And then if I really like it, well, actually, I'm going to go and take a step up and buy a more perpetual license or whatever it is to use and consume, whatever. So then you've got different time frames, different levels. And again, that could come into part of what you're buying, not just for the license, but for the duration as well.
Yeah, there's an intermediate step too. I imagine that there are licenses that say you can have and use this thing essentially forever, but you can't remix it or distribute it again, right? I could certainly see those coming up, if only because it would kind of mirror the vinyl example you're using, right? Which is that you can have this record, you can play it for yourself, but if you put the speakers out the window, you've got a problem with the Beatles, and Apple Records, right? Those variations we're talking about when it comes to licensing of these copyrights are those things that it's possible to deal with on a technical level. Like that's no longer a binary decision tree, right? Like, right? So, but I imagine it is possible. But you guys tell me, is it possible to have these exploding licenses, etc., built in?
Yeah, I mean, another thing that is probably worth mentioning is that my feeling is that the mechanism of license exemption works reasonably well only when you have very few powerful actors that produce material. Because I can create a vinyl with some songs on it with a very standard licensing. Then if someone wants to include those songs in a movie, they have to request for a license exemption or a different license for that usage. That is fine, because how many people actually make movies and use that song in a movie? But in the internet world, that's not true. Everything is totally interconnected. We see it with memes, for instance. Memes are the ultimate headache for copyright. These images that get constantly reused and recycled and remade in different ways by everyone. And so, it's totally unreasonable to expect that we can use a license exemption in mechanism in that case, because if your NFT becomes viral, you will receive thousands of requests for license exemptions that are all different, probably in just one day. So that's why you want a mechanism instead that allows you to say, okay, you can do this, you cannot do this. And maybe it's the artists themselves that if they say that their license is too restrictive, they decide to change it to ensure that, there is more degree of virality in the work they make.
Yeah, as you're talking about it, it occurs to me that maybe the future of this is a different kind of power and rights when it comes to copyright, right? Like the standard way we've seen it play out, to go back to the Beatles example, is the Beatles have a lot of power and weight behind them, and they can just say no, right?
Exactly.
And they have the resources to go out and stop people, right? But that doesn't work at scale. Like everybody who's created a song, if you hear them in a pub, they can't stop you from using it later, right? Well, in the natural world, something that's always fascinated me is the difference between strong and weak forces. The strong forces are essentially like the ionic or electrical bonds, which are very powerful on the micro level, hooking things together. But on a global and galactic level, it cancel each other out. They're useless. Whereas the real powerful things are the weak forces, like gravity, which everything gets to have some gravity, and every bit of gravity gets to affect everything else. But it's very, very weak. But it's what holds everything together in the great spiral of the galactic arm, right? If the copyrights change to a weaker force, it can make it so that everybody is able to derive some value from what they added to the NFT chain without shutting the system down, without saying no. And maybe these mechanisms could give people that ability to exert that force over a remixed NFT chain. The one of 8 people not powerful if it's part of the mechanism. Maybe it could do that. That would be fascinating. And just like on a galactic scale, it could be what changes everything.
Also,
works,
by the
right?
way, but by the way, I also think that in practice, there will be very few cases where, for instance, you actually need to produce original contracts and new legal, atoms in this system. There is a huge herd effect. Many people will just stick to, some very well-known licenses. And I think that as soon as you implement something that is equivalent to AGPL, MIT, Apache, and all these big licenses, basically the overwhelming majority of people will use those things. Also, in my very limited experience with, legal stuff and business, it was very funny to see that every time I had to incorporate some entity, there was this phase where, you look at the things and you say, okay, all these laws really are not really good for me. I'm doing something very particular and I need something more ad hoc. And 99.999% of the times that's absolutely false. It's just that you can't read between the lines in the right way. Those laws come from literally hundreds of years of practice.
Yeah.
And 99% of the times, I'm sorry, but your project is not original enough to require, to rewrite the entire legal corpus of a country just to be accommodated. So this is a very important thing. I think that in the end, presented in this way, this seems like a mess. But I think that in the end, after, we formalize some very tiny bits and some very fundamental concepts, we can already go a long, long, long way.
So yeah, I mean, what you see is the concepts. It's like ownership and duration seem to be the ones we're talking about, right?
So that's
And I, yeah.
Yeah, that's the most difficult part to establish actually, because I'm not a legal scholar. So yeah, this is this is maybe a question for you. That is, what do you think are the most atomic legal concepts that we can use to
So
to create complex legal systems?
So from copyright, the elemental idea is the idea of creation, right? That you created a work. So there's the moment of creation is important because it establishes primacy. So a creation point is important. And then authorship or creatorship. Who was there at the creation? Copyright, in fact, has a lot of problem in the new technology world dealing with the idea that there might not be a creator, right? But copyright presupposes that. So creatorship in the moment of creation. And the copyright rules generally start a clock ticking at the point of creatorship. So there's a temporal component tailing off from that, right? From that point, it is scope of use. And there are kind of two elements of it. One is seems workable and the other doesn't. One is, do you have permission for the use, right? And so that would be a big part. The other is, if you don't have permission, is it fair use otherwise? That other one seems too messy to ever break down into the kind of systems we're talking about. That's the last resort of messy legal systems. It's those things get resolved by legal violence, not by any kind of thinking, right? But the idea of permission, that's closer to a binary decision, right? Did you get permission or not? And then the question is, what is the scope of the permission, right? To the extent that in that scope seems harder. But those are the starting points elementally. I wish some of our other colleagues were on this. We could ask them more about it. My colleague Jen, who's been in other conversations of these, I know has litigated some copyright issues. The idea of ownership and authorship is something I've been working on with our friends Lad. But yeah.
The question there for you, Chris. You mentioned there about it's not always clear who the creator is.
Yes.
On a chain, we always have a transaction associated with something. So we can with certainty, well, I suppose, unless it's a smart contract that's created something, then normally it's an address, a transaction's been signed by somebody with a key. So at that point, you should in theory know who the creator is. Or is that not always the case?
And you also should know the time.
Yeah.
And you can take the block number.
All that's real valuable, right? Because what it does is it resolves what a lot of the legal fights would be in the copyright context, right? Like who had authorship first? I mean, sometimes there's convergent, without bad faith, convergent creation of things, right? Like go back to calculus. Leibniz and Newton create things essentially contemporaneously and independently when it comes to calculus. But the roughly contemporaneous would get resolved in the blockchain world because you'd say, well, yeah, Leibniz did it on October 1st, but too bad because in September when Newton started writing Principia, but it would be settled on a blockchain where everybody could see it. There's a lot of value to that, and that would reduce some of the inefficiencies in the copyright world because you wouldn't have to fight it out, and lawyers wouldn't have to get involved other than to say, here are the timestamps. That's the promise of it.
Another important thing is when it comes to authorship, basically, as Martin was saying, you can always find an address that either created something directly or initiated some kind of process with a smart contract, because smart contracts on blockchains always have to be called by some address. So you can always say, okay, you can, for everything, you can explore the trace of the computation and always get some address that originates transaction. And you can say, okay, I will consider whoever controls that address to be the owner of this thing, unless differently specified on the license. So you have a mechanism to basically say, I'm creating this on behalf of someone else. This is very common with big artists that, traditional artists that start creating NFTs. Presumably, the NFTs are not created directly by them, but they have some technical team that helps them to develop the NFTs. So in that case, in the license, you would say, I don't know, this artist is the owner of the thing. But otherwise, yeah, you have a way. And this is, I agree, it's very, very valuable.
Yeah, another thing that I should mention is the concept of publication. The idea that you've made your work public in some way matters for copyright purposes. But again, that's addressed by the structures we're talking about here, because these things are public. The worry on that would be if you had these convergent creations and somebody, invented or created something and just kept it in their garage, and the other person put it out in the public.
Oh, you can solve this as well if you think about it, because we have these wonderful things that are called cryptographic hashes. A cryptographic hash is basically you take a file and you produce a string out of it. There is, like, if you vary the file just a little bit, the string is completely different. And the point is that it's exactly very difficult to invert. Like, if I give you a string and I ask you, can you produce me something that encodes to that string? That is an amazingly hard problem that is basically unsolvable. So what you can do is you can publish the hash of something you created on the blockchain with a given license. And in that case, you are not revealing yet what you created. But at a later stage, you can prove that your piece of art or your NFT or your code hashes to the hash you provided at that point in time. And at that point, you have a proof. You can say, I will prove you at a later time that I created this thing 3 years ago.
Yeah, that is interesting, because you can maintain secrecy while still being public about your claim of ownership. Yeah. Yeah, no, that's a very interesting point, because it's not one that would be workable in the old framework, but seems like the laws would embrace it, at least to a certain extent. Yeah, that's an interesting twist on it. So we think primarily the utility of this right now is for copyrights. We think it'll streamline things and make it easier for people to work in these spaces, specifically NFTs we talked about. What other promise do we see with this kind of systematizing of the licenses and et cetera? Other than the NFT development itself, I guess is what I'm getting at.
Well, for me, it was just like an interesting question. When Anya and myself were talking about this, that's like the idea of trying to, formalize things as made from smaller pieces. It's just like what I do in my daily life, in my daily work. So it was just interesting for me to try to tackle this problem from my own perspective. I don't think it is up to me to say what this thing can be useful for the simple thing that I am not a legal scholar. And I don't think my answer would in some way be, really on point. But,
well, let's flip it on you then. What gets you excited about systematizing it this way? Because obviously you've got affinity for doing this. I'm sorry, Martin, it looks like you're about to talk.
Yeah, I think we're seeing parallels to this with some of the smart contracts and the way that we're looking, say, in finance at taxonomy. So taxonomy is obviously important in finance, that we're talking about the same things. When I talk about a dividend, what do I actually mean by the actual dividend, the payment terms, and so on and so forth? And we create the standard taxonomies, and it feels a bit like what we're looking at here from a slightly different point of view than NFTs is being explored in other areas of the blockchain. So it's possible that we may see a bit of convergence from standard taxonomy, standard licensing, and then we can start, rather than just throwing the word NFT around and Creative Commons, with the taxonomy combined with the licensing, we'll start seeing a lot more structured products around, as in, we all understand that this is a music video. We all understand this is a piece of art. This is whatever it is, a claim on the first bottle of wine out of a Californian vineyard, whatever. All these different types of things will develop and grow, I think, in parallel. And this comes back to sort of the componentization, if I could pronounce it properly, but like a systematic approach to things of, metadata describing using taxonomy plus the licensing. So I think we're really at the beginning of it all, and the particular issue, the pressing issue with NFTs is the copyright part of it. But this is just the beginning of it. We also need to understand, you know, in terms of categorizing using taxonomy, what we're actually buying.
Yeah, no, I mean, that's an interesting point. You know, when we talk about copyright, we have the treaties to work off of. That's the shared taxonomy can be built off of that. But you mentioned the trade terms in the finance world. You know, those are built off of trade terms that are thousands of years old, some of them, right? Like the idea of full on board is something that had a specific legal effect when you ship something 3,000 years ago, as the same effect now, as the same effect everywhere in the world, no matter what legal system you have. There are certain shared terms that have developed organically, just from the process of business being done over and over again. It sounds like in the finance world, you've hammered out a number of those too. Not to say there aren't fights, but that organically grown shared taxonomy seems like an opportunity too. Just like
well, if we can minimize those fights down to maybe 15 terms rather than the 1,000 terms that we regularly use, then, you know, that's got to be progress, hasn't it?
It does. Yeah. I mean, it's less work for me, but I'll take the piece. Yeah.
Yeah, that is, I think Martin nailed it completely. Like, this is exactly the point. The point is, when you have a way to combine smaller things into bigger things so that complexity doesn't spin out of control, then it's way easier, for instance, to analyze the things you have at hand, to replace them. The simplest case I can imagine is that in a system like this, if you're not satisfied with some part of your license, you can just change one little bit. And the system will tell you if you have to change something else or not. But, you know, if you have a monolithic contract, like a monolithic piece of code that is not, you know, coded by using calls to other pieces of code, then every time you want to change something, it's a mess. Like there was this very kind of old programming construction, very famous, that is called Go-to. It's like in the first programming languages.
Basic. Yeah, true basic.
Yeah. And so you say, okay, at some point you have some control that says, if this happens, go to this line in the code. If this other thing happens, go to this other line. Okay. The problem with that is that as soon as you edit your code just lightly, obviously line 22nd, now it becomes line 37, and your go-to is making you jump to some completely different place, and your code is going to misbehave big time. So very, very quickly, programmers and programming language designers got aware that this was one of the worst ideas that you could have in computer science. So ultimately, we still compile to things that use that stuff, but the point is that we don't do it ourselves anymore. We're writing languages where these kind of constructors are completely forbidden. And then when we use the compiler retranslate our language to something more like basic level that uses this instruction. So we create a layer of protection about it.
I think another programming analogy is interesting. If as we develop software languages, it's still scary if a system hasn't really got unit tests around it. What a unit test does, it tests that each small part of the program is actually behaving as it's supposed to. So if I'm putting a number in plus another number, I'm expecting to see a number out at the other end. As a basic test, I put those around that. What that means is I can test all my code, and when I make a small change and say, well, actually, I'm not going to use a number here, I'm going to put a vector in, then it will blow up, which is nice. But then you might find it blows up in 14 other parts of the code base somewhere because you got the unit test around. It gives you the confidence to do that. Now you think, big deal. How does this apply to what we're talking about now? If you don't have that in place, what people are finding is that we have complex systems. You look at that and say, whoa, that looks terrible. I'm going to put my own little code in here to say, if it's Martin coming along trying to do something, just forget that code and go through my new path. And then you end up with multiple paths going through the same thing. You might remember to change 4 of them, but 5 and 6 you've forgotten about, in which case it all blows up. So again, back to what we started with, was having this check to say, all right, have we covered everything? is it all compatible, or will this blow up? And blowing up means it's incompatible in the copyright sense.
Yeah.
And in the blockchain space, it's very nice because you could create like DAOs that are, you know, working by bounty hunting this kind of stuff. So I could say, hey guys, I found that legal nugget number 2 and legal nugget number 37 are actually incompatible if you think about this particular context, and this is not in the packet manager yet. So people can use these 2 bits at the same time, and this could create problems in this situation. So you see, you can then have people bounty hunting this kind of problems in a way or another, which I think is very interesting.
That's a nice approach. I like that.
Yeah, the current framework of copyright involves some bounty hunting to it, right? Which is wherever you go onto any website, there's a Digital Millennium Copyright Act notice, which says, hey, tell us if there's a copyright problem. If you go on YouTube, if you go on any of the social medias, even very lawless places worry about copyrights because the mechanism is simple and enforced in a crowd force kind of way, which is people make their notices. Once you get the notice, if you don't take an action, there are penalties for it. So the easiest thing to do is to take down the thing, resolve the issue, and then move on. The Dmca, which is the acronym for that, has been fascinating to me for that, because it's so widespread now, and even in the lawless areas of the internet, it's something that seems to be enforced. You'll have places that are notoriously non-cooperative legally, and they'll still have a Dmca notice on the bottom of their, and you can't get in touch with them. You know, there's no live person to talk to, but you can put it in a Dmca complaint. So it's fascinating to me. I do not, by any stretch of the imagination, think that's the best way to deal with these things, but the efficacy of it on some level indicates that what you're talking about, Fab, could be really interesting, to have like these DAOs hunting for this stuff, to use that impulse.
I think there is also another interesting aspect about thinking, you know, about the relationship between like representing licensing on the blockchain and NFTs, for instance. That is, it is my opinion, and that's probably quite niche, that contracts themselves, like legal contracts themselves, can be used as a form of art. So what I mean is all my friends here where I live are basically contemporary artists. So I had a lot of discussions with them about what is art, what is not art. And like I had this mental experiment, right? Imagine that I create a work of art that is basically a closed room. And before you go in, you have to sign a contract. There is someone that says, please read the contract very carefully. And the contract states something really like awful stuff, like there is the entering in this room will provide a very high risk for your health. And there's very likely that you will feel very badly, and you know, you waive all responsibilities and whatever. You read this thing and you are like scared, you know, like, okay, then you decide maybe to go in. And the point is that it doesn't matter what you go in. The emotional state that you are in when you actually come in contact with the art is provided by the contract itself. It's provided by the fact that the thing you are reading that you consider to be an official document is saying, hey, take this thing seriously and grant me the authorization to waive my responsibility in what you're going to do. I think this is very interesting, because you could say that the real emotional engine of a work of art like this is not what's in the room. It's the fact that you have to sign the contract to get in the room. And I am...
There's another way to approach it. As a more legalistic one, you do the reasonableness test. So you've scared me by saying this is going to be emotionally shattering for me to enter this room. And I'm going to go in and say, actually, no, this isn't a reasonable contract. And I'm looking more at the wording than actually trying to feel something in this room because of the contract before.
but you see, I'm willing to bet anything you want that if we implement a way to represent legal licenses and contracts on blockchain as tokens, people will start using those tokens themselves as work of art. And we will have a huge kind of new way of doing art that is literally like trolling the law in one way or another by creating contracts that are totally meaningless and then take the NFT out of it, and all this kind of stuff. That, I mean, that will be something very excited to see, and in a way it will literally elevate, I think, legal practice to an art form even more than it is today, which is very, very funny when you think about it.
Well, yeah, I mean, I look at some of my colleagues, and sometimes it appears that they are Dadaists by the way they're doing their job. So yeah, I can see that performance art as law. Yeah. Okay. Well then, was there anything else you guys wanted to talk about on this? No. The debate on law, I mean, debate on art, Fab, got me thinking. I have an uncle who's a poet. And he used to debate me on those things too. One of the things he'd talk about is he'd say, art, what does art mean to you? I'd try to come up with a definition. He'd always say the same thing. He'd say, art is something that has no utility at all. That's the only thing that could be art. I didn't necessarily agree with him, but by way of capping up this conversation, I hope our conversation is not art. I hope that using his definition. All right. Well, thank you all. We'll talk again soon at the next episode.
Thank you.
Bye.
Bye.